We'll now call case number 126870, State of Kansas versus Alvarado-Meraz.
May it please the court. Deborah Wilson, Capital and Conflicts Appellate Defender, appears on behalf of the defendant appellant, Luis Alvarado-Meraz. Luis Alvarado-Meraz was convicted of capital murder. He was sentenced to life without parole, and this is his direct appeal. This capital murder conviction was for the shooting deaths of Manuel Alvarado-Meraz, who is Luis's twin brother, and Manuel's wife, Lucero Rodriguez. The shooting took place in the apartment that the three of them shared in Wichita. Before the shooting, all indications were that the three roommates got along well and that the twin brothers shared a particularly close bond. And there was very little evidence in this case as to what preceded the shooting or what provoked the shooting. And perhaps because of this lack of evidence as to what led up to the shooting, and in particular, what happened immediately in those hours and minutes before the shooting, four of the citizens who served on Mr. Alvarado-Meraz's jury, KAJWECNRB, and voted to convict him of capital murder, testified under oath that during their deliberations, they had a question or questions about premeditation, that they conveyed this question or questions to the trial court, and that the trial court provided a response. One more juror who died before post-conviction proceedings submitted an affidavit to that effect. Three more of the citizens who served on this jury recalled that they had questions during deliberations. Those questions were conveyed to the trial court, and the trial court answered them, but they couldn't remember the subject of the questions. Those were RH, RVDB, and MD. That's a total of 8 jurors who said their mid-deliberation questions were answered by the trial court. The other 4 jurors who served in this case, AJ, NM, RS, and AC, who was the foreperson of the jury, could not remember whether it happened or not. The bailiff who served on this case testified that she didn't remember this case, couldn't remember. The trial judge had no specific recollection of this case, although the trial judge said, if I'd had a question from the jury, I would have followed the statutory procedure. This evidence is the basis for our claim that Mr. Alvarado-Meraz's rights to be present for this critical stage of his proceeding under the Constitution and under Kansas statutory law were violated. But the post-conviction court found against Mr. Alvarado-Meraz on factual grounds. The post-conviction court determined that Mr. Alvarado-Meraz had failed to prove his claim. There were 2 underpinnings to the trial court's finding. First, the post-conviction court said the jurors didn't agree as to how this happened, so you didn't establish your claim. And second, the post-conviction judge expressed his opinion that it was untenable that the trial court would not follow the statutory procedure. Now, your review of this case is mostly de novo because most of the factual determinations that the trial court made were based on transcripts of previous proceedings as opposed to live testimony. So why should I talk about the post-conviction court's rationale? It's because I hope I can convince you today to not adopt that approach to this evidence, that it's simply untenable that the trial judge would make a mistake like this.
Don't we have to kind of transport case law from other areas to get to a de novo review here?
I think the case law is pretty clear. I mean, there is case law across a lot of other areas that says when the factual findings are made on documents, whether it's contracts or leases or transcripts of testimony, that this court is in as good a position as the trial court to make credibility determinations. And I know that the state said, well, you haven't cited any case that a motion for new trial can be reviewed this way. Well, our claim isn't that, oh, this court always reviews a motion for new trial de novo. Our claim is that it is the nature of the evidence in this case, that it was written evidence, as opposed to I am looking at this witness in my courtroom and evaluating their demeanor and their credibility, that puts you in the position of exercising de novo review. And you do it in cases that are quite similar to our claim here, because we're alleging a violation of constitutional rights, and frequently in 1507 motions, where all the evidence in the case is documentary, you exercise de novo review.
That's really hard to do here because these witnesses are all over. There's just so much. And as you read their testimony, it almost seems like they're wanting to please whoever's asking them questions, because some of them, it's like black at one moment, white at the next. Oh no, back, I'm black to back. And so when you just look at a transcript, it's really difficult to sort that out. So if we don't want to jump into those muddy waters and we move past that, where I'm kind of having trouble analytically is, I understand you're not asking for this to be deemed to be structural error. Is that correct?
Yes.
So if we're looking at harmlessness, don't we have to know the substance of what was talked about? And we have nothing that, other than the broad description of premeditation, we really don't know what the questions were or what the answers were.
Well, if you find error, we have to get there first. If you find error, then the burden is on the state to show that, because it's constitutional error.
Well, I'm struggling with that. I think we maybe need to be a little more precise, because in thinking that through, the state has to prove the error was harmless. But you have the burden to prove the error. We agree.
Right.
Have you proved error? You've proved error, yes, you have. But who has the burden to prove what the substance of that error was? I mean, is the state supposed to just box at all the possible ghosts of all the possible questions that the jury would have had? And when the jurors tell us they have no memory of what those particulars are, then what happens?
First, I'd like to point out we do have, let's see, let me count the jurors who said that the subject was premeditation. KAJWECRB all said that it was in fact premeditation. Do we know what the specific question about premeditation was? We don't, but whose fault is that? It is not Mr. Alvarado-Meraz's fault. He was the one, if you find error, he was the individual whose rights were violated. So I do not believe it's incumbent upon him to prove what the particular subject of these conversations was, because he has no way to prove it, because there was no record preserved of this discussion. And I want to push back a tiny bit, Justice Luker, against your assertion that the jurors are all over the place. You are accurate in that the jurors are all over the place with regard to specific details. But the 8 jurors who testified all established what I would say is the elements of our claim, because the elements of our claim don't involve the details of how the answer was delivered to the jury. Did the judge come into the courtroom, or did the bailiff come into the courtroom? Rather, the elements of our claim are these. The jurors had a question or questions during their deliberations that were conveyed to the court. Those 8 jurors are consistent on that. Number 2, we received an answer from the court during those deliberations. Those 8 jurors are consistent on that. And number 3, Mr. Alvarado-Meraz was not notified of the question, was not given an opportunity to participate or be present in this.
And there's some indication that seems like the most definitive indication is that the answer was on a written piece of type paper, and the inference is that that was likely the jury instruction itself. And the defense counsel is on record of saying, had they been called, his suggested response to the court would have been to refer the jurors back to the written instruction. So where does that leave us?
Well, I think it is very likely, frankly, that they were referred back to their instructions. We don't know that for sure, but I think it's very likely. And that's because RBEC, MD, RVDB all described the bailiff coming back in with an answer. And RB, his testimony would tend to support the idea that they were told to look at the instructions. EC said, we asked the question in writing, we didn't get the answer we wanted. The bailiff came back again and said, look at your instructions. MD said, I don't remember if the question was about premeditation, but as he put it, my brain says the lady said something like it's all in the sheet. RVDB also said that a woman came back in with the answer, although I'm not sure on his case whether they were referred to the instructions. I think it's very possible that the judge decided I'm just going to refer them back to the instructions and made a mistake and didn't realize that even when you tell the jury just go back to your instructions, you're providing them with an answer to the question.
Is that really an answer to the question? I mean, isn't it a non-answer?
To refer them back to the instructions?
Yeah.
Well, the defendant certainly has the right to have notice that the jury has a question, to have notice what the question is, to hear the court say, here's what I propose to do, and to put on record his or her suggestions or objections to the trial court's proposed.
That makes sense to me. But if the response of the court is essentially the I have a question. Well, I'm not going to answer your question. Look at your instructions. Doesn't that isn't that a factor to weigh in the harmlessness analysis?
But once again, since it was Mr. Alvarado-Meraz's rights that were violated here, if you find error, I'm kind of jumping ahead, but since it was his rights that were violated and the nature of the violation was such that he has no information about what actually happened.
Well, I understood you to say that the best conclusion that can be drawn from the evidence is the court referred the jury back to their instructions.
That's one that can be, and I think it's fairly likely, frankly.
Okay, so given that,
yes,
can you argue harmless that this was not, or what's your best argument to rebut the state's claim of harmlessness?
Perhaps the jurors wanted to know how much time does premeditation take, or what acts indicate premeditation, especially on this time element.
That goes to the substance of the answer, and that's not the error that you're claiming. The error you're claiming is he wasn't present.
But if the jurors are expressing confusion and that they need further guidance on this, the defendant at least should have the opportunity to weigh in and say, I don't think a referral back to the instructions will answer their question because they have the instructions in front of them. And clearly this isn't enough for them. And premeditation is the central issue in this case. And so I think that that's why it's not harmless. I see I'm out of time, but I would also say another reason it's not harmless, if the question was in fact about premeditation, another reason this isn't harmless in this case is that the evidence of premeditation in this case is not overwhelming. I'm not making a sufficiency argument, but is it overwhelming? Could anyone look at this case and go, oh yes, both these murders, because you need 2 premeditated murders for capital murder, both these murders were premeditated. And the evidence there is not overwhelming, especially when you don't know. This kind of ties in with our prosecutorial error argument. You don't know where the weapons were located in the apartment before the shooting started. We don't know if there was a fight. There was some indication that there was a fight or conflict immediately before. So because the evidence of premeditation wasn't overwhelming, I don't think the state can sustain its burden of proving that the error was harmless in this case, that beyond a reasonable doubt, it didn't affect this verdict.
And can I take you back to where you started on the standard of review, and maybe help me confirm in the record that Judge Ward did hear live testimony from some witnesses?
Correct.
Who were those witnesses? Judge Gehring.
He heard from the judge, he heard from the bailiff, and he heard from the foreman.
Foreman, right. And I assume you're not suggesting that we would apply de novo review to those, assuming there are findings tied back to that.
Yes, yes. And I'm comfortable with their testimony too, because it was, I don't remember. So.
Okay. All right.
Thank you. Mr. Gillette?
Thank you, Your Honor. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will focus the majority of my remarks on the first issue here today. And to begin out of the blocks, the standard of review here has to be abuse of discretion. The defendant is, in their brief, sought de novo review of the entirety of this case. I've heard a little bit different stance today, just from the podium, but I still don't see any authority offered or even a suggestion as to why that would be reasonable. This court does not reweigh evidence. The defendant cites no authority by which this court can act as a finder of fact anew, particularly regarding a motion for a new trial. And the state maintains that they have abandoned this point by merely pressing it without offering any authority for this court to do so. Of equal import here, I don't want this court to lose sight of the fact that the defendant invited any error in how the court handled the review of the evidence in this case by their actions, by the way they elected to litigate this post-trial motion over roughly 3 years. There was no objection when the case was reassigned from Judge Woolley to Judge Ward. There was no objection to Judge Ward's order for additional testimony in January of 2022, where he was clear that at that point in time, even, he had reviewed the court file and the transcript from the prior hearings and testimony, and concluded that he wanted to hear from Judge Gehring and the presiding juror. There was no objection to Judge Ward considering the entirety of the evidence and its weight. In fact, Judge Ward gave the defendant explicit opportunity to make this claim or make a challenge below, and the defendant elected to go with allowing Judge Ward to review this record as a whole and act as the fact finder. It simply makes no sense to, and I don't know how this court would have to try to parse partial de novo review of a portion, and then deferential review of another part. Respectfully, it does not track, and in part because it's not what happened here, because it's not what the defendant wanted to have happen here. The defendant chose to try to pursue this case in the way that he did because he thought it could maybe have some success. But frankly, it did not work out that way. And the reason why is frankly pretty clear. The state would begin in talking. I want to talk about the jurors just a little bit, and I want to begin with juror EB, because I think it's telling of how we got to this complete all over the place, as Justice Lukert described it. This evidence was all over the place. There's not an error demonstrated. Part of the reason that the state suggests that the defendant failed to even establish an error is what juror EB testified to is that defense investigators showed up and came to talk to them. I don't actually remember if juror EB was a male or female. Juror EB told them that Judge Gearing did not come into the jury room during trial and that no one else had come into the jury room in trial. After trial, defense counsel generated an affidavit for juror EB, which implied that Judge Gearing had come into the jury room, and she refused to sign it. That's how this investigation started. And as a result, you end up still all over the place, despite placing potentially immense pressure on jurors well after the fact. Because I'd also note that the timeline here, as this court certainly recalls, much of the delay and the litigation of this happened through COVID. This was at a time that was not easy for people to just go about their day-to-day life, much less remember the jury trial that they had sat on months, years ago. But to the extent that they could, the state actually takes a different view of the evidence here, because I think that the evidence, when properly viewed, paints a very different picture. From the state's perspective, there were 5 jurors, including the presiding juror, who, while not all perfect, their memories were not all perfect, but they all indicated that no one came into the jury room to answer a jury question like the defendant claimed. The aide, she testified that she had nothing to add. Nothing at all about this trial stood out to her. Judge Gearing, likewise, nothing at all stood out, but had a jury answered a question, he was definitive. He would have followed his standard procedure, which is to abide by the statute and this court's precedent. Respectfully, the defendant's position today is essentially just reweighing evidence. Juror KA demonstrated a spotty memory, only offered that they were pretty sure that there had been a question. She thought that the judge had come in, but she couldn't remember a number of things, including the question itself or who answered it. Again, we're all over the place. We don't know anything from that. Juror MH was pretty sure that the judge had came in before and after the verdict, and that before the verdict, she thought he answered some question about precedent. Again, we're all over the place. Could that have simply been the judge coming in after the jury had rendered their verdict and had been ordered back into the jury room to await dismissal? Absolutely. There's just absolutely no support for the defendant's position that there was any action by the court here where he had a right to be present that was violated.
Counsel, I apologize for interrupting. I cannot find in my notes. Did Judge Gearing testify in front of Judge Ward?
Yes.
That was what I thought, but because the conflict earlier and all that.
Correct.
Okay. So that credibility finding presumably comes out of the de novo review that counsel asked for. I mean, Judge Ward believed Judge Gearing when he said, I didn't go into the room. So that should be off the table from an appellate court standpoint.
Correct. No matter your standard of review, that credibility finding would stand.
Yeah.
Yes. Juror JW believed that a question had been submitted to the court, but acknowledged they couldn't remember how, who, or what it was, and agreed that the foreperson would be the better person to answer this question. And the foreperson was explicitly clear, no, there was no question submitted nor any answer delivered during their deliberations. RVDB was very sure Judge Gearing did not come into the jury room as the defendant claimed. And I think what may be starting to emerge here for the court is that the defendant's claim was also all over the place. Was there simply a question? Did Judge Gearing come into the courtroom? Did he answer it in writing? And we even saw more of that today, where defense counsel for today acknowledges that the closest thing that any of the evidence could have even got them to, looking at it in the light most favorable to them, was that the court delivered a written answer directing the jury to refer back to their instructions. That's the closest thing that we can get to. Accepting that Your Honors, we are done. This is absolutely harmless. If that even happened, this would be an absolutely harmless error, and review can end at that point. Juror B, who is the individual that submitted an affidavit. That affidavit was not made part of the record below, which should also be, and so is not part of the record on appeal. That should also be telling. And then juror NM was 95 to 99% sure Judge Gearing only came in after the verdict. She also supports the state's position throughout that there was not a jury question asked or answered in this case. Defendants claim that 8 jurors testified without contradiction that they received an answer or answers to their questions must ring hollow. Alternatively, as conceded here today, even if the most likely scenario based on reviewing the evidence, de novo in the light most favorable to the defendant, it's harmless. If something happened, it has to be deemed harmless. Briefly, with the time I have remaining, I'll briefly just mention the prosecutorial error remarks because it came up at the end of the opposing counsel's argument today. The state maintains that arguing the evidence and proper inferences that may be drawn from it cannot constitute prosecutorial error. There was no prosecutorial error in this case, nor did the prosecutor misstate premeditation in any manner any different than this court has done in times before when writing its own opinions. It was an accurate recitation of the instruction defining premeditation, and then a restatement of it consistent with that definition. The evidence did show that the victims in this case, the defendant's twin brother and his twin brother's wife, his sister-in-law, they were ambushed. They were shot multiple times with a pistol and an AK-47 rifle.
The defense argues that the definition of ambush includes the concealment of the person, you hide and then you surprise them. If we look at that dictionary definition, what is the evidence that supports the ambush? Use of the word ambush.
I think the definition, I would start by saying the definition of ambushed is more than that. I would also, and then as far as the surprise, or even if we wanted to stick to that definition, I think the evidence here was pretty clear. The sister-in-law was sitting at the dining table eating dinner, and the twin brother was in the kitchen getting dinner. And as the prosecutor argued, and as the evidence showed, the defendant at least at some point had those guns in his room. So he would have had to go into his room, retrieve those weapons, and then come out and start shooting right away. And he killed them both right where they sat.
And backing up to in his room, that's just based on
his own photographs of himself in the room with the guns
on a different date. So there were times they were in there, but on the evening or the time of the shootings, that's an inference that's just drawn from the location of the shell casings, or what is the inference on that at that time they were in the room?
I think it can be drawn from both the shell casings, and I think it can be drawn from the direction of the shots. I don't think we should cast aside the fact that the defendant had those guns and had posed with them in his room as though they are his. I understand there was some ammunition in a different place in the house, but that doesn't mean that the guns were stored there. And in either event, I think the evidence, when properly viewed, would still support an ambush. They were surprised. They had no idea what was coming. They were shot in their backs. Nothing more, when viewing the evidence properly, is necessary to support that these two victims were ambushed by the defendant. See no further questions, or if your honors have any further, I'm happy to stand for additional questions, but we would simply ask that the conviction is in this case, or the conviction for capital murder in this case, be upheld, and that the defendant continue to serve his sentence. Thank you, your honors.
Thank you. You reserve 3 minutes.
Thank you, Your Honor. This is not at all personal to Mr. Gillette, but it makes me really mad when prosecutors say that that I've abandoned an issue by failing to adequately brief it. The question of the standard of review here, whether it's de novo or not, I cited 2 cases in my opening brief that explained that when evidence is documentary, this court has de novo review. And then because the state said, oh, you didn't adequately brief it, I reiterated in my reply brief that the standard of review doesn't depend on the type of proceedings. Rather, it depends on the type of the evidence. And I cited more cases. Alvarado-Meraz versus State, which was a 60-1507 motion, Crawford versus Raby, which was a dispute over an oil and gas lease. So there's plenty of case law here that says when you've got transcripts and documents, you exercise de novo review. I also would like to push back on this idea of invited error. We're not claiming that Judge Ward erred by using the transcripts. We didn't know. They did not object below to that. We're just saying that the nature of his fact finding changes the standard of review. We are not at all claiming he shouldn't have done it in this case. I would also like to point out that the investigation in this case did not start with the defendant, did not start with defense counsel. It started when jurors told post-conviction counsel, oh yes, we had our questions answered during the deliberation. I also stand by my assertions that the other 4 jurors said they don't remember. They did not refute the claims. They said, I don't remember. AJ said his testimony was at volume 8, page 74. I don't think so, but honestly, I don't remember. I honestly don't remember. Sorry. NM, she was asked, did you send any questions to the judge? Response, volume 8, page 81. I don't remember. Questioned again, did the jury submit any oral or written questions? Answer, volume 8, page 82. I don't remember. RS, did the jury send any questions to the judge? RS said on page 87 of volume 8, I can't remember. And then said, I want to say there might have been, but I don't remember. And AC, the foreman, he did not refute this either. He remembered they had questions. He could not remember if they submitted any. That's at volume 10, page 11. And he said, we very well could have, but I don't remember. Volume 10, page 12. And it does not matter to the defendant's claim whether they proved Judge Gehring came into the courtroom. Judge Gehring said he didn't. We can accept that because the claim is there were questions, they were answered, there was no notice. And with regard to the prosecutorial error, I just want to say that I have seen the prosecutorial error continue in this courtroom today. As Justice Lukert, as you pointed out, no one knows where those weapons were in the hours or the minutes or the seconds preceding the shooting in this case. There's a picture of the guns in Mr. Alvarado-Meraz's room at some point before this happened. There are also pictures of all 3 of the roommates handling the guns in that case. To assert, first of all, to assert directly twice, and then to imply once, the defendant went back to the bedroom, got the guns, and came out and shot the victims. And that shows premeditation. That's prosecutorial error because there is no evidence that that happened in this case. And also to continue to assert that the shell casings showed that the defendant came out of the room shooting continues the errors because the state's own witnesses, the firearms expert and the crime scene expert, when questioned, can you tell where the shooter was standing? Can you tell whether the shooter was moving or standing still when this happened? Those experts said you can't tell anything by these shell casings. because first of all, the casings and the fragments are ejected depending on which way the gun is held, which we don't know, and they ricochet, and depending on what they hit and ricochet against, they can go everywhere. And people come into the crime scene and kick the casings everywhere. So I'm seeing the error continue here. And it's important because the idea that the shooter came, first of all, that the shooter went to the bedroom, retrieved the weapons, came out again, implies, of course, that the shooter had time to reflect rather than this was an impulsive act. So I believe that this is error, arguing facts not in evidence. And I believe that the prosecution cannot show that it's harmless. We'd ask that you reverse Mr. Alvarado-Meraz's conviction and grant him a new trial. Thank you.
Thank you. Thank you to both counsel. We will take this matter under advisement.